he's sitting to your right, Mr. Sitting, Mr. Bradford, and he realizes that. I often tell people in divorce court about my own father's situation. My father was a man who was a World War II veteran, and he had his issues and demons from the war, and drank to excess on a regular basis, and was not particularly a great father for a period of time until about 1963, when we moved to Houston County over in Erin. Never touched another drop. He became an elder in the church and turned his life completely around. So I'm a big believer in people having the opportunity to correct their lives and get on with, a better portion of their life. So my job requires me to also take into consideration the fact that a person, even though he's now changed as a result of having found this, owes a duty to society to pay that debt that he incurred. So I tend to agree with General Wojciechowski that less than 30 days incarceration is not sufficient for a person who has not only failed to and absconded from it. And I say that because absconding from probation violates the cardinal rule of probation, which is that the person report to a probation officer, or else there's no reason to have probation if there's no reason to see if we don't supervise. So it is my opinion that the 30 days that he is, less than 30 days sentence that he is serving right now is not sufficient. But I also believe that in a sense he should also be required to show that he has changed his life. And under 4035-308 of the Tennessee Code, it allows me to find that a person who has violated his probation can be extended on probation. His probation effectively was stayed by the imposition or by the obtaining of the warrant in October. I restart his sentence now and restart it with the length of time that he, I think, was actually pled guilty in July and was absconded with the affidavit of his violation in October. So that will be the starting of his sentence over again. In other words, his sentence will start from the date that the warrant was issued for violation of probation, and the remainder of that 2-year sentence will commence probation as of this moment after I'm finished with this sentencing. In addition to that, under 4035-308, it provides that I may extend his probation for up to 1 year, and I do extend his probation up to 1 year. So he is restarting his sentence. I've extended his probation for 1 year. I order that he serve a sentence of 45 days. Following the sentence of 45 days, he will return to complete the original remaining portion of his 2-year sentence on probation and an extension of that probation for 1 year. So he's essentially going to have a little over 2.5 years of probation now to be. I will authorize his probation to be transferred since it is felony. He can be transferred to the state where he lives now. I'm not sure where that is exactly, but wherever that is, the Department of Corrections will have to handle that transfer. I fully expected at the outset of this hearing to revoke you to serve your sentence because of the simple fact that I see a violation of the cardinal rule of probation is you don't report. I have looked at your medical records. I've reviewed these things. And if I'm ever going to believe in the power of rehabilitation that's available to someone, then I have to have some sort of faith that somebody's going to actually turn their life around. And so I am giving you that trust and that credit. And if you violate that trust and that credit, then you can understand that I'm going to revoke you and have you serve every day of that sentence. If you live up to that trust that I'm placing in you and all of these people who have testified to have lived up to, then I will think that I've made the right decision. You have the opportunity you're going to be a father. If you have the opportunity to be as my father and turn your life around and be somebody who can show that there is a capacity for change in your life, And that's the judgment of this court.
Sorry.
I need to make that payment.